There is a new legal kerfuffle going on here between Attorney General of Texas, Ken Paxton, and the Biden administration. So this is an interesting case I want to go through. It's surrounding this idea, this concept of what's called a public charge. And a public charge is sort of the idea that if somebody comes into this country and they're not able to support themselves, if they can't find a place to live or food to eat or a place to get medical care, they can't find a job. Well, whose responsibility is that to care for that person? Well, it's ours. It's society. We don't want people to be dying on the streets. And so we all got to care for them. But when it comes to immigration law, they have to consider these issues because resources are finite. And the question then becomes, when people are trying to immigrate into this country, is there some sort of analysis that is going on to determine whether or not these people will ultimately be public charges? And if so, what do we do about that? And so very interesting sort of procedural history here. Let me show you this document. This is being submitted into the U.S. Court of Appeals for the Fourth Circuit. And you're going to notice that this is Casa de Maryland versus Joe Biden. All right, so it's a private company as plaintiff suing Joe Biden. Well, what's interesting about this is this originally was against Donald Trump. Okay, but Trump didn't win re-election, as we know, and so Joe Biden is now in office. So this originally goes back to a prior rule where the Trump administration was trying to decipher and sort of define what a public charge was. And so they defined that. Then they got sued because nobody liked that definition of a public charge, or at least, some obviously a lot of people did. They're being sued to bring back that definition, but Casa de Maryland did not like that. They sued the Trump administration over it, and there was a back and forth. Trump is not in office anymore. So now the lawsuit is against the president. So now Joe Biden is the president, but now Joe Biden doesn't want to enforce the Trump rule that the original lawsuit was about. So Biden and the plaintiffs are now kind of on the same side. The plaintiff was suing. They didn't like the rule. Trump's not in office anymore. Joe Biden comes into office. Joe Biden says, we don't like the rule either. So that rule is going away. So now because the defendant and the plaintiff are kind of on the same side, they both agree that they don't like the rule. The court just said, all right, we're going to go ahead and dismiss the case because there's nothing to argue about anymore. And now Attorney General Ken Paxton is saying, hold on a minute. You didn't consult with any of us. This is an important issue. We rely on that rule. We rely on it for our law enforcement budgets. We rely on it for our immigration enforcement. We are planning our cities around this. And you're just going to dismiss this debate that's going on about this rule and not hear from any of the states that it's ultimately going to impact. You're just going to let the executive come in and just modify things. It's going to have adverse impacts on our various states. So Ken Paxton is now appealing this up, and they're seated in the Fourth Circuit. So let's go through this. I want to show you how many states are involved. It's a big deal. We've got Casa de Maryland, local disclosure statement. None of this stuff really matters. Look at the states over here. We got Texas, Alabama, Arizona, Arkansas, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Montana, Ohio, and Oklahoma. So we've got a lot. We've got state of South Carolina and West Virginia, all joining in on this lawsuit. And so some of these are border states, obviously, Texas, Arizona, we sort of here on the right on the southern border, and others are in the southern United States. And so they're seeing some of the impacts of immigration. We're going to go through here. Let's take a look at the introduction. So all of these states are seeking to intervene in this case. They want to get involved. So they were not originally involved, but they want to intervene. They want to defend the duly promulgated rule that is interpreting the Immigration Act's prohibition against immigration by those who would become a public charge. So in other words, if you are somebody who is trying to immigrate into this country and you are going to be a public charge, according to the Immigration and Nationality Act, those people are going to be barred from entering the country, right? They're not going to be in here. 2 days ago, the named defendants, so that would be Joe Biden, who are agents and agencies of the U.S., they filed a stipulated motion to dismiss, which means they agreed with the people who were filing the lawsuit. Biden agreed with Casa de Maryland, and they stipulated to dismiss the case. The court granted that motion, and then it issued its mandates without offering the affected parties, which are the states, any opportunity to seek to defend the rule. So they just made a decision on their own. They didn't talk about anybody else that this might impact. The rule that they are now seeking to revise directly implicates the state's obligations in providing Medicaid and other social services to indigent and low-income individuals. Moreover, the states, especially border states, have strong interest in enforcing the rule, which properly interpreted and implemented Congress's long-held policy of immigrant self-sufficiency. The request is timely because this court made its mandate just 2 days after the United States announced it would no longer defend the rule. Interested parties had no ability to intervene before it did so. So the president, Joe Biden, and his administration just said, yeah, we're not going to defend the rule anymore, so dismiss all of the claims. The United States did not inform the states that it intended to cease the rule or cease defending the rule, and states did not have an opportunity to even get involved or to say anything. It goes on. A little bit of background here. Let's look at the U.S. Code. So this is 8 U.S. Code 1182A4A, and it says here, under federal law, any alien who, in the opinion of the Attorney General at the time of application for admission or adjustment of status, is likely to become a public charge is inadmissible. The immigration case concerns the hotly contested public charge rule. So if they are a public charge, they are inadmissible. And this is existing U.S. Code, 8 U.S. Code 1182. So the question here is, how do we define this term? What is a public charge? You can see here the definition is pretty clear. It's likely to become a public charge is inadmissible, or the rule is clear, but we don't know what a public charge is. So the Trump administration tried to define that. Here it is. In 2018, following extensive notice and comment, Department of Homeland Security issued a final rule adopting the definition of public charge. What does it say? The new rule says a public charge is, quote, an alien who receives one or more public benefits for more than 12 months in the aggregate within any 36-month period. So what does that mean? If over 3 years, 36 months, you accumulate more than 12 months of, let's say, government support, public benefits, doesn't matter. They don't have to be, it sounds like they don't have to be consecutive. So you don't have to spend a year on public benefits. But if you just spend, let's say, January, take February off, get a temporary job. Oh, you need public benefits in March. But in April, you get a job, you have some side work, and on and on and on. Well, you add up those different months. And if you, in the aggregate, accumulate 12 or more within 36 months, then you don't get to be considered admissible into this country. The rule further explains public benefits includes non-cash benefits that are partially funded by the states, including Medicaid benefits. The plaintiffs here, Casa de Maryland, and 2 individuals, they sued against the president, Department of Homeland Security, and other federal defendants in their official capacities. The plaintiffs allege that the rule violates the APA, Fifth Amendment, going to be due process issues there. They moved for an injunction. The district court granted the motion, and it stopped the federal defendants from enforcing the rule anywhere. So in other words, the lower level district court said, you can't use that rule, Trump. Sorry, it's not going to happen. Not going to happen anywhere. Then the Court of Appeals reversed that. It said it held that the rule rests on an interpretation of the public charge that comports with a straightforward reading of the statute. The panel further ruled the district court erred in its choice of a remedy by issuing a plainly overbroad nationwide injunction. So it goes through the district court. District court says, yeah, you can't do that rule. Court of Appeals says, yeah, actually you can, because it's pretty reasonable based under the statute. Then the plaintiff said, well, now we want a rehearing en banc. So we want the full court to hear it because it was just a previous portion of the court. In Court of Appeals, you'll get sort of a panel ruling where you'll just get 3 judges who issue a ruling, and you can say, well, we don't like that ruling, so we want the entire court to rule on it, which is what they did. The court called for a supplemental briefing to explain what's going on. The defendants here, President Biden, shortly thereafter, let's say the court called for a supplemental briefing. The defendants responded that on February 2nd, President Biden issued an executive order directing a review of the rule, so that the defendants suggested that the court postpone the oral argument until that review is complete. The court agreed, removed the case from oral arguments. Then, March 9th, without beginning the process to rescind the rule or provide notice to the other parties, defendants filed an unopposed motion to dismiss. Court granted that motion, and now they're trying to get involved and say you should not have just eliminated that rule so easily. Because the defendants will no longer defend a rule directly implicating the state's interests, the state now moves the court to withdraw its mandate, reconsider its dismissal, and for leave to intervene in defense of the rule. So all of those different states are now going to get involved, or they're asking the court to allow them to get involved so that they can step in and defend this rule that says that if you are a public charge for more than 12 months of 36 months, or if they can sort of analyze you and consider you to be in that category, then you are not admissible. So why should this happen? What is Paxton's argument? Why should this go into effect? What do the states have to argue about here? It says here the court should recall the mandate because it has the inherent power to do so. Extraordinary circumstances justify recalling the mandate where the state state intervenors were presented with no opportunity to preserve their interests. Until March 9th, the states were represented by the United States. The United States did not inform the states that it intended to withdraw its defense of the rule. So the states were relying on the federal government to represent the defense of this rule because they're the government. They're the ones who are in charge of that rule. It was a rule that was carried over from Donald Trump. We know that, but it's still with the U.S. government. So if the U.S. government is going to abandon the defense of the rule, shouldn't the states who are relying on that rule be notified about it? This is depriving the states of an opportunity to intervene prior to its dismissal. Likewise, the court almost immediately issued the mandate following the motion and once again precluded the states from getting involved. This harms the states, which include multiple border states, from allowing the district court's nationwide injunction to take effect are severe, which is going to hamper the state's ability to act in a period of great budgetary uncertainty. The mandate should be recalled. Why? The court should stay the mandate because this is going to be submitted on a writ of certiorari up to the Supreme Court. And it's also going to be likely that the Supreme Court grants certiorari. So we can see here, they're going through some sort of legal case law. You can see here, it says here, the final rule's definition of public charge is consistent with the relevant statute. It's not arbitrary. It's not capricious. And so the Second Circuit has found a similar rule to exceed the scope of the delegated power. Let's go on. It says, this question is vitally important. Decisions about whether and under what conditions to admit immigrants implicate, quote, fundamental sovereign attribute exercised by the government's political departments. So this is one of the primary functions of government, is to control immigration. And so when the federal government is interfering with this, the states need to be notified so they can respond accordingly. Second Circuit noted, saying that making these decisions correctly is essential because, quote, there is no apparent means by which Department of Homeland Security could revisit adjustment determinations. Congress explicitly directed the executive branch to deny admission or adjustment of status to aliens who, quote, in the opinion of the Secretary, are likely at any time to become a public charge. It's in the U.S. Code, they're saying. The rule provides key guidance in doing so, issuing formal, objective standards by which the determination will be made. And so they're saying the Supreme Court has already once determined it on the merits. They're saying there's a significant possibility of reversal so that if they actually listen to this case, the states will prevail on the merits because the rule is lawful. For more than a century, they say, it has been the immigration policy of the United States that aliens within the nation's borders not depend on public resources to meet their needs, and the availability of public benefits not constitute an incentive for immigration to the United States. That long-held policy formed the basis of the public charge rule. Congress never defined the term public charge, but, quote, the ordinary meaning public charge was one who produces a money charge upon or an expense to the public for support and care, which sounds like a pretty good definition. It's coming from Black Law's Dictionary, which is sort of the gold standard for legal dictionaries. The rule reflects that ordinary meaning by defining as public charges those individuals who rely on individual benefits for a prolonged period or multiple benefits for a shorter period of time. But Biden just got rid of that rule, just with the stroke of a pen through his executive order. Now the courts are not going to be enforcing it. And so they're trying to appeal this. We got one more slide on this. There is a likelihood of irreparable harm absent a stay. So what happens if the government does not allow the state to get involved, the multiple states to get involved and defend this lawsuit? What happens if the Court of Appeals says, well, no thanks, we already made our decision, we're not going to hear from you? Biden administration already determined what the ruling is, we're going to stick to that ruling. Well, what happens to the states? What's going to be the harm? Is it irreparable harm? Let's look. Here it says, allowing the mandate to issue and permitting the district court to vacate the rule will cause irreparable harm. State suffers an institutional injury from the inversion of federalism principles. When an injunction, the district court's judgment reverses a formal rulemaking process upon which states have relied. So states have relied on this rule for what? Law enforcement and budgetary policies without allowing them input would allow a formal rescission of the process. It interferes with traditional state prerogatives for the reasons described in the accompanying memorandum in the motion. As the court is aware, this is a time of considerable financial strain on all the states because of the pandemic and the economic downturn. Immigration can be a driver of cultural and economic growth, this says, but Congress has recognized for over a century it can also strain the public fisc. By definition, individuals whose receipt of benefits depend on the definition of public charge are among the poorest in our society. Because such benefits can never be recouped, states will be irreparably harmed if the rule cannot be enforced while its legality is resolved here and elsewhere. So what that means is they're saying that we need to issue a stay, keep the rule in place while we're able to make some conversations and make some maneuvers about what to do with our original policy. We've already been acting a certain way. We were already processing and analyzing potential immigrants into this country under this rule. Now you're modifying it. We've already been relying on it to our detriment. And so if you're going to be considering getting rid of it, we at least need to stay so that we can start mitigating some of the harm caused by the abdication of the rule. You can see here, signed off by basically everybody. We have Ken Paxton. We got Brent Webster over from Texas. We have Steve Marshall, Alabama. Mark Bernovich over here from Arizona. What up, Mark? We got Leslie Rutledge. We got Todd. We got Derek Schmidt from Kansas. Daniel Cameron from Kentucky. We heard about him in the Breonna Taylor case. Not a fan. We have Jeff Landry, Attorney General, Louisiana. Lynn Fitch, Mississippi, Montana, Ohio, and others. So interesting case here. Now, Attorney General Paxton is also going after the masks. So he's going after Biden on immigration, and he's going after his own state, Austin, the city of Austin, over mask mandates. So here he is. This article comes over from hotair.com. Says Attorney General Ken Paxton threatened to sue the city of Austin on Wednesday over the city's continuation of a mask mandate. Governor Abbott removed the statewide mask mandate last week, and his order went into effect on Wednesday. And they're saying here that the mayor from Austin wants to keep masks until at least April 15th to avoid another surge of cases. They're saying now that Paxton told Adler and Brown they had until 6 p.m. last night to rescind the mask mandate. No dice. As far as I can tell, nothing changed as of 6 p.m. Came and went. The war of words escalated. So here it is. Texas Attorney General on Twitter is posting over there, says, Mayor Adler, Andy Brown, you and local health authorities have until 6 p.m. today, this was 2 days ago on March 10th, to rescind any mask mandates or business operating restrictions and come into full compliance with GA 34. Otherwise, on behalf of the state of Texas, I will sue you. People will kill each other over these masks. It's, as we can see, we're having some lawsuits, our first mask lawsuits that we've covered on this channel. Maybe there are others. This is the letter that was sent from Ken Paxton over to Judge Brown and Mayor Adler. It says, over the past 24 hours, Travis County City of Austin officials announced that local orders requiring individuals will continue unabated despite Governor Abbott issuing otherwise. It says here, there are no COVID-19 related operating limits for any business, according to the governor. In short, GA 34 has the force and effect of state law and supersedes local rules and regulations. The decision to require masks and otherwise impose COVID-19 restrictions is expressly reserved to private businesses on their own premises. It does not rest with jurisdictions like the city of Austin or Travis County or their local health authorities, nor do they have any authority to fine or threaten fines for noncompliance. We've already taken you to court under similar circumstances. You lost. If you continue to flout the law in this manner, we'll take you to court again and you will lose again. To that end, you and your local health authorities have until 6 p.m. today to rescind any local mask mandates, retract any public statements, and come into full compliance. Otherwise, on behalf of the state of Texas, I will sue you. For liberty and justice in Texas, from Ken Paxton, AG of Texas. So he's on one over there in Texas. I'm not even mad about it. Here it is. To be clear, the governor's authority exceeds that. So that's over from hotair.com. You can go check that out. Let's take a look at some questions here coming over from locals.com on this immigration issue. Here is one from Dr. Renal MD, who says, at Robert Barnes. Robert Barnes is not here. This is Robert Gruller. Robert Barnes, nice, very nice fellow. We had an interview with him recently, but he is another Robert. But I know who you're talking about. I think you're talking to me. He says, most of the public charge involves healthcare. I would challenge those who state, quote, healthcare is a right. If it is, when has a right ever been enforced on the backs of others? Does this right allow the government to make me work extra hours for free? What a slippery slope we are going on. Yeah, and that's from a doctor. That's from an actual doctor. Dr. Renal, NY Renal MD in the house. Yeah, I mean, I don't know where that concept came from. I don't understand where all of these rights came from. Everybody wants a lot of rights to do a lot of different things that I don't know where they came from. Very curious. All right, but it's a good question. We have liberty or death. Our last question from this segment says, Mrs. Liberty is an immigrant. Thinks that Creepy Joe is absolutely wrong here. Yeah. You got a good one over there, Liberty. Doesn't understand how we are expected to accept the unilateral changing of the law by the president for the illegal alien, or why we are importing poor people when we have our own. She was wondering what law or laws the American citizen is allowed to break to tell the court, yes, I did that, but I am otherwise law-abiding. What law or laws the American citizen is allowed to break to tell the court, yes, I did that, but I am otherwise law-abiding? Well, this is going to be a good question, and I don't know what the long-term solution is going to be on this immigration issue. Now, I understand what Biden and his people are doing. Of course, they want to be compassionate, right? We talked a lot about immigration reform. We talked a lot about lifting people up and how awful Donald Trump was with all the kids in cages and on and on. Okay, so now they have rescinded a lot of the Trump rules. Now we see just this massive surge of people coming up. Why? Because the Biden administration created some pretty strong incentives to do that. Donald Trump created some strong disincentives, and Biden is creating incentives to encourage people to come across the border. And now when they get here, the question is, well, what are they going to do about it? If you recall, during the Trump administration, this was kids in cages. This was kids who were being locked up like animals, you monsters. But today, now it's just, what are they called? Temporary facilities. These are immigration centers, processing centers, and they've got all these nice little, fluffy phrases that they wrap around the same concept. And they're little centers are going to break if the numbers keep up. And so they're going to have to decide what to do with this. And how are they going to sort of approach it on the back end? Are they going to be sending people away at the border? Are they going to come to the border and just turn them back? Doesn't sound like that. It sounds like they're going to be able to come into the United States, be kept for a certain amount of time while their asylum claims get processed. And because there's nowhere to house them, they just get set free. They just get released into the United States. And the big question here, the big issue that a lot of people who are concerned about unbridled immigration happen to have is that, are they going to show back up to their court proceedings? Are they going to follow the process when there's really no incentive for them to do so? And it's going to be very curious as to where this goes. It feels like that they sort of are shooting themselves in the foot. They created a bunch of incentives. They've already demagogued the hell out of any solutions that other administrations have attempted to implement in order to stem the tide. And now they're going to have to deal with the consequences. And the American people are going to have to see what that feels like and how they like it. We can already see AG Paxton is trying to get involved here on this lawsuit and others. And I think Governor Abbott from Texas ordered 500 National Guards down to the border, which is like a blip. Right? It's basically nothing, but the states are going to have to start taking this stuff back into their own hands if they want to control their borders. All right, good question.